Hey everyone, Harry here to talk about Stephen Miller's announcement that the administration is considering whether to suspend habeas corpus in the event that the courts don't get it right, is how he sort of put it. In other words, in the event that the courts in fact, press the habeas corpus remedies of people, thereby finding that there were violations of the Constitution, then the administration thinks, per Stephen Miller, it can just kind of, forget about habeas corpus, and therefore it thinks forget about all review and do whatever the hell it wants, including forgetting about the Constitution of the United States. Okay, first, man, he is all wet. And this guy, it's funny. He stands up. They really like him, and he stands up and says stuff. But any lawyer knows he is really completely out of his lane. He's the guy who announced to Trump that the unanimous Supreme Court ruling about habeas corpus that went against the administration actually was a 9-0 unanimous victory for the administration. So his stock in trade is saying outlandish, obviously inaccurate things in this sort of flat, lawyerly tone that I think he thinks communicates a kind of sense of authority about the law, but he is completely all wet. Okay, let's think about I'll spell out, I'll probably be writing about this, but why he is completely all wet when it comes to this suggestion that the administration will suspend habeas corpus if there is not the right rulings by the court. All right, let's just start with, under the Constitution, it is not to the executive to suspend habeas corpus. It's very circumscribed and rare when you can do it, but it also has to be by Congress. I know you're saying, what about Abraham Lincoln? What did he do? And it's true that during the Civil War, for a very specific time and place, he did suspend habeas corpus. But the courts later ruled, actually it was a court of appeal where Chief Justice Roger Taney, not the most distinguished, it's true, Supreme Court Justice, he wrote the Dred Scott case, but anyway, held this is unconstitutional. You cannot do this. This is the ex parte Merriman case. This is Congress's job to do. Lincoln did it anyway, and there is a kind of dispute historically that really doesn't matter for what we're talking about now. Some would say what he did was legit. Some would say what he did wasn't legit, but it was the exigencies of a civil war and things that don't exist now. And most importantly, after he did it, Congress authorized it retroactively. So it's a very, there's a strong argument that Congress did it anyway. And so, it fully complies with the Constitution. Again, both as to who does it and when they do it, because this is such an important point. It is in the Constitution, which says the suspension clause, which is in Article 1, as everyone knows, that governs Congress, that you may not, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. So it's not simply that it can't be done by the executive, but there has to be a showing that we have rebellion or invasion. They love that invasion point, right? That's what they're saying in the Alien Enemies Act, but every court has rejected it. Rebellion, forget about it. There's no, rebellion implies an attempt to overthrow by U.S. citizens and the like, whoever the Tren de Aragua gang is. They're not rebels of the United States in anything like the normal idea of that term. So we don't have Congress, we don't have rebellion, we don't have invasion, and the public safety doesn't require it. the members who are going to be deported are locked up anyway. There's just no showing of some kind of, perilous public safety. So under the Constitution, it's wrong in a multiplicity of ways. It's got to be Congress. There's got to be a rebellion or invasion, and the Public Safety Act to require it. So forget all those things. Now, that's 19th century stuff. Do they have an argument? Well, maybe it's okay now. And the answer is no, even more emphatically. So this came up in the aftermath of 9/11, where a series of cases come to the court when the administration tried to basically imprison or even punish Al-Qaeda members outside the province of the normal courts, meaning federal habeas corpus. And the court again and again and again rejected it. So first, in just the overall effort to detain a citizen as an enemy combatant and therefore not give process, Justice O'Connor famously says, a state of war is not a blank check for the president. So even less is the presence of, you name it, a couple hundred Trende Aragua members here. Then they next tried to say Guantanamo Bay, that's like the same kind of argument they're making for El Salvador. That's outside our jurisdiction. They have functional control of it, but it's Cuba's territory. And the court again said, no, location doesn't eliminate habeas rights, which, by the way, matters a lot now for this whole case, because everyone down there, not just Abrego Garcia, has habeas rights, and their basis for detaining them, the Alien Enemies Act, has been forcefully rejected by 3 different courts. And then finally, and most importantly, Boumediene versus Bush is where Congress, in fact, the right body, tried to strip the courts of habeas jurisdiction for detainees. And the Supreme Court, per Justice Kennedy, I believe, said, you can't do that unless there's the equivalent protection around. There isn't the equivalent protection around. So therefore, the effort by Congress is unconstitutional because you need habeas corpus to protect basic constitutional rights. So this statute they did to try to suspend it, and it was Congress, the right body, and it was, I think very arguably a time of war, or at least a time when Congress had passed an authorization to use military force in the wake of 9/11. But the court still said, no, you can't do this if it leaves the prisoners without basically any rights. Think about that here, by the way. Remember what the Supreme Court said 9-0 was that the right way to do this, well, actually, I'm sorry, what they said 9-0, there are rights. And then they said, a majority of them said, you got to do habeas corpus, not, as Roseberg had done, the Constitution per se or the Administrative Procedures Act. If somehow the habeas corpus avenue were shut down, which it won't be because it's done improperly, but if it were, it could well be under the authority of Boumediene that the things they had relied on as invalidating because habeas corpus was around and had to be, maybe then they become the equivalent of federal habeas corpus rights and they shift into action. So for 16 reasons, no way Stephen Miller will get his great dream of having the courts just not even look at everything they want to do in the treatment of illegal or legal aliens. They need some legal basis. And if they want to suspend habeas corpus, they need Congress. They need a time of invasion, which they don't have, or rebellion, and they need public safety requiring it. I don't see that happening without, and they're going to try to say, by the way, as to all these things, the president gets to decide it without any review. It's up to the president whether there's a rebellion. It's up to the president where public safety requires it. And all of the cases I cited, the 3 in the wake of 9/11 and the Lincoln case itself, ex parte man, stand for the proposition, and again, It'll be the courts that decide, and this is just a baseline proposition, whether any suspension is lawful in the first place. And I'm here to tell you, I don't think it is, and I don't see the courts green lighting it. So, sorry, Stephen Miller, but you're this new brainchild. He's also the one we gather who came up with the interpretation of the Alien Enemies Act that's been so decisively rejected by 3 or 4 different courts now. This new brainchild of suspending habeas corpus won't hunt. And, we're at a point now where basically any legal opinion that Stephen Miller grants to the press or the president should presumptively, I think, be discounted. But this one is, as was the Alien Enemies Act, all white. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.